You want to get negligence straight? I'm here to tell you, you gotta go through the elements. This one's going out to law students and people studying for the bar. Let's say you've covered negligence in your torts class by now or your bar prep course. Here's a couple questions. You could ask yourself, what have I learned? How can I use it? The answer to both is elements. When you're approaching, could be a multiple choice problem, could be an essay issue spotter, you want to ask yourself what claims can be brought, and then for each claim you want to go through the elements and then go through relevant defenses. Now, not everyone approaches torts or negligence with elements. Not every professor goes that way, not every judge goes that way, not every casebook goes that way. I've got a lot of books around here. I pulled some torts casebooks, started looking through the table of contents. Here are some of the topics that I found in some torts casebooks that are not organized by elements. They just give you a bunch of topics. They just hit you with topics like these. What do I do with this stuff? Is a question you might have, and going through the elements gives you a way to approach it, plug this stuff in and use it. I actually know someone who didn't understand that torts have elements and you could go through a tort element by element until they were at the end of the semester in their torts class. And that person went on to become a law professor, a very successful one. Not me, but this is a true story. Let's say you're a plaintiff, you want to bring a negligence claim. In a sentence, here's what you have to prove by a preponderance of the evidence. The defendant owed me a duty of care. They breached that duty, thereby actually and proximately causing me an injury. Now that's in a sentence, but what we want to do is break it down into elements. In elements, that's 5 elements. Existence of a duty, breach of duty, actual causation, proximate causation, and injury. 5 elements. Hold on a second, you may be thinking, whoa, my professor, my casebook, they break it down into elements, but they didn't have 5. They had a different number. Don't panic, okay? They're not talking about a different tort law. There's just one tort law, but it's just different people break it down different ways. You know, I break it down into 5 elements, a lot of people do, but some folks will break it down into 4 elements. They'll, for instance, collapse actual causation and proximate causation into one element of causation. That's fine, all right? It's not wrong. It's just a different breakdown, but it's the same torts substance. It's not different law. You could do 3 elements. You could put breach and duty, existence of a duty and breach of duty together as breach of a duty owed. You could have 3 elements. All right, it's just a different breakdown. It's not a different tort law. It's the same tort law, just broken down in a different way. But whether it's 3, 4, 5 elements, it's all the same. I like to have all 5 elements because you know what elements are? Really, it's a checklist. It's just a checklist for you as a law student or for you if you're a judge. Some of y'all will be judges someday and come here sooner than you might think. It's a checklist for you when you're a practicing lawyer trying to figure out if your client has a good case. Thinking of elements really just means having a checklist for a prima facie case. And that's why you can use it even if your professor doesn't talk about elements. Now, maybe your professor or the case you're reading talks about elements, but it doesn't use the same terms as I've used. Don't panic. It's all the same tort law. Sometimes things are just called by different names. For instance, some people, instead of actual causation, they call that same set of stuff causation in fact. That's very common. They're both correct. How can they have different words for the same thing, you might be thinking? There's no one authority who's in charge of what words to use. It's a common law subject. Similarly, proximate causation, some people call that scope of liability. There's nothing magical about the names. This isn't a statute, it's the common law. The names are sort of arbitrary. Injury, some people refer to that element as damage or damages. Substantively, it's the same thing. It's the checklist to make sure, whether you're a court, a lawyer, or a law student, that your negligence analysis is complete. Now let's go back to this list of topics that I pulled out of some case books. Now, some of these, standards of conduct, negligence per se, child trespassers, res ipsa loquitur, custom, all really are things that you use under breach of duty, or that you can use under the breach of duty element. So you can put all those things as possible tools to bring to bear on your analysis under the breach of duty element. Some of these other topics kind of go to multiple elements. Probably wouldn't have organized my casebook that way, but it's fine. It's not wrong. It's just different. All right, now here's what I want to do to help drive this all home so you can see how it all works in the wild, in the real world, is take you on a little trip using the magic of your imagination to beautiful Colorado, and let's look at some pattern jury instructions. So you know that when a case is submitted to the jury, the judge instructs the jury on the law so that they can reach a decision in accordance with the law. The judge gives their instructions. Now, here's the secret. Judges actually have a kind of fill-in-the-blank jury instruction book that they like to work from, okay? So they can avoid coming up with their own jury instructions from scratch, which is good. But also, let me tell you something. Trial judges hate several things. But one thing they really hate is they hate being overruled by an appeals court. So a trial judge figures if they use these pattern jury instructions that typically have been created by some statewide committee and kind of blessed with their approval, some statewide committee of lawyers and well-respected judges comes together and they write out these pattern jury instructions. And then a trial judge figures if I just use those pattern jury instructions, I'm less likely to get overruled. And that's probably true because trial judges hate being overruled. They also hate discovery disputes and they hate rude lawyers. Okay, so you got to have a discovery dispute. You got to have a discovery dispute, but don't be a rude lawyer. Judges hate that. Let's look at these pattern jury instructions from Colorado. So these are fill-in-the-blank instructions we could give to a jury. 9.1, elements of liability. For the plaintiff, name. That's where you're supposed to fill in the name of the plaintiff. For the plaintiff name to recover from the defendant name on his/her claim of negligence, you must find that all the following have been proved by a preponderance of the evidence. 1, the plaintiff had injuries, damages, losses. There's your injury element right there. That's the injury element, all right? The defendant was negligent. Well, what does that mean exactly? Hold on. Flip the page here to 9.6, negligence defined. Negligence means a failure to do an act which a reasonably careful person would do, or the doing of an act which a reasonably careful person would not do under the same or similar circumstances to protect oneself or others from bodily injury, death, property damage, insert any other appropriate description. So that's describing breach of duty. Okay, good. So we've got the breach element right there in the jury instructions. Okay, number 3, the defendant's negligence was a cause of the plaintiff's injuries, damages, losses. All right, causation. Where's actual causation, proximate causation? All right, flip to another page. 9.18, the word cause, as used in these instructions, means an act or failure to act which, in natural and probable sequence, produced the claimed injury. That's talking about proximate causation. Next sentence, it is a cause without which the claimed injury would not have happened. That's actual causation, or causation in fact, they're talking about in that sentence. So cause in these jury instructions includes the concepts of both actual causation and proximate causation. All right, so we had injury, breach, actual and proximate causation. What happened to duty? Where's duty? Because we said that was one of the 5 elements of negligence, but I didn't see it in the jury instructions. Okay, hold on. Let's flip to the front of the book. There's an introductory note at the beginning of the chapter for the negligence instructions. Here's what it says. It says, generally, a legal duty to use due care arises in response to a foreseeable and unreasonable risk of harm to others. Okay. In determining whether a person has a duty to act or refrain from acting to avoid injury to others, the nature of the inquiry is essentially whether recognizing a duty would comport with fairness under contemporary standards. To decide this, the court must consider several factors. The existence and scope of a legal duty are generally questions of law for the court to determine. Questions of law for the court to determine. In other words, it is not the jury's job. That's why it wasn't in the jury instructions. So we've got all 5 elements of negligence represented there in Colorado. It's a checklist. It's a checklist that we go through, make sure our analysis is complete, comprehensive, whether we're a judge or a lawyer trying to figure out if the client has a good case, or a law student taking a torts exam, or someone taking the bar exam. That's how you do it. You go through the elements. Say them with me now. Now you have to ask yourself, where are you watching this video? What are the social norms? Okay, but if you're by yourself, say it out loud with me. Say all 5, will you? Existence of a duty, breach of duty, actual causation, proximate causation, and injury. Let's do it again. It feels good. Existence of a duty, breach of duty, actual causation, proximate causation, injury. 5 elements. We need all 5 to prove a prima facie case. All 5 are required. And if we do prove all 5, we've got a prima facie case. Then we're going to win. Unless the defense comes back and knocks one of them out on a rebuttal defense or proves up an affirmative defense. That's the elements, the power of the elements. So when you approach a negligence problem, ask yourself what claims can be brought. For each claim, go through the elements, then go through relevant defenses. You've got this.